Hello and welcome to the AIFC Court and International Arbitration Centre Webinar Series 2020, New Opportunities During and Post-COVID-19. Today we have Webinar 6 in our series. The topic is Freezing Orders, Other Interim Measures and Ex Parte Applications at the AIFC Court. Today's speaker is Justice Charles Banner QC. Justice Banner QC is a judge in our AIFC Small Claims Court. We have 1 hour for today's webinar. Justice Banner QC will give his presentation and we will then open the floor for questions. If we may ask you, please, if you have any questions, please at your leisure type them in the Q's and A's option, which is shown at the bottom of your screens. Justice Banner QC will then answer the questions, perhaps with my help if necessary, at the end of his presentation. So thank you very much for joining us today. Without further ado, I'll hand over, please, to Justice Banner.
Thank you very much, Chris. Dobry dzień, Katarzyniu. Ja tylko chut gawry paruski, поэтому я буду говорить по-английски. So for the non-Russian speakers, I just thought I'd say, unfortunately, my Russian isn't very good, but I wanted to greet people in Russian first. It's a real pleasure to be able to give this webinar today. I'm sorry that due to the coronavirus, I've not yet been able to visit Nur-Sultan this year, but I hope I will be able to do so soon. I'm very pleased to learn that the AIFC Court and International Arbitration Centre has now administered no fewer than 80 cases overall. That's really excellent news, including there having been 2 judgments of the court, 3 arbitration cases and 75 mediation cases at the International Arbitration Centre, all of which have been administered online using the e-justice system and video technology free of charge. So it's great to hear that there's been so much progress despite the challenges of the recent months. And it's also really great to see what an impressive webinar programme there has been already and continues to be over the next few weeks. And I commend the subsequent webinars to all those involved. My webinar today is going to be focusing in particular on interim measures. By way of introduction, an interim remedy or interim measure is something which is applied for and granted to cover the intervening period between the start of proceedings and the final judgment or order, having effect only for that temporary period. It is to be contrasted with a permanent remedy, which is granted ordinarily at the end of the proceedings and lasts forever thereafter, subject to any subsequent orders of the court. The provisions in relation to interim remedies are set out in the Astana International Finance Centre Court rules, which I call, for ease of reference, the ACR in these slides, in Part 15, which has fairly detailed prescription for interim remedies. The court rules, for anybody who needs an introduction to them, are set out in online on the AIFC Court's website, and there's also extremely useful hard copy, which I know is available at the court, and Chris has provided me with, I think I've got 2 copies now, which are already very well used, and they should be the starting point for anybody seeking to understand what interim remedies are available and how to go about seeking one. Part 15 is the section, as I mentioned, which deals with interim remedies, and it's structured into, broadly speaking, 4 parts. Rules 15.1 through to 15.3 explain what interim remedies are available. Then there are 3 sections which follow. Section 1, which sets out general proceedings relating to the process for seeking and indeed resisting an interim remedy. Section 2, which sets out provisions relating to interim payments, and I'll discuss interim payments later. And Section 3, dealing with security for costs. And again, I will talk about that concept in a few moments' time. Rule 15.1, as I mentioned, sets out the interim remedies that are available, and I think it's worth just going through to start with the list of interim remedies available. I put in bold the particular remedies that I'm going to spend some time talking about in more detail later. So the first of which, the remedies, is an interim injunction. An injunction, in simple terms, is something which requires a person to do or not to do something. and like other orders, if they breach that order, then the person is in contempt of court, and there are measures available for them to be fined for that contempt. An interim declaration, I'm going to give an example of that when I come to talk about freezing orders. An order which can cover various aspects of property, and property includes broad concepts, both land and other forms of property assets, for the detention, custody, inspection or preservation of property, for taking of a sample of relevant property, for carrying out of an experiment on or with relevant property, for the sale of relevant property which is desirable to sell quickly, and for the payment of income from relevant property until a claim is decided. Then number 4, an order authorising a person to enter any land or building in the possession of a party to the proceedings for the purpose of carrying out one of those orders. An order providing for the delivery up of any goods to the claimant or a person appointed by the court on terms and conditions prescribed by the court. And then I've bolded the next 2 because I'm going to talk about freezing orders later. So an order referred to as a freezing order, restraining a party from removing assets from Kazakhstan or from dealing with assets wherever they may be located, and that includes globally. An order directing a party to provide information about the location of relevant property or assets, to provide information about them which either are the subject of a freezing order or which may be, and that can be used in appropriate circumstances to seek to identify whether there are assets which can and should be the subject of a later freezing order. A search order, that's an order requiring a party to allow somebody else onto premises for the purpose of preserving evidence, which may be used at the trial. An order for production of documents, including before a claim has been made. An order against a non-party, somebody perhaps standing behind a claimant or defendant, requiring the production of documents or inspection of property under the control of that third party. An order for an interim payment, for payment on account of damages or any debt or sum apart from costs. As I'll talk about that in more detail. An order for money to be paid, or specified funds to be paid into court. An order permitting a party seeking to recover personal property to pay money into the court pending the outcome of proceedings, and directing, if he does so, the property should be given up to him. An order requiring a party to prepare and file accounts relating to the dispute, and an order directing any account to be taken or inquiry to be made by the court. An order appointing a receiver. And then finally, where the person against whom the order is made is a natural person, order appointing the receiver, and so on. And finally, any other remedy provided by any other legislation. And I note that 18, and just going back, the introductory words of 15.1, the court may grant such interim remedies, including leave open the possibility, in an appropriate case, that an interim remedy not included in that list may potentially be found to be available. So that's the list in very general terms. What about the overarching principles applicable to interim remedies? The starting point is the overriding objective, which is the golden thread running through the AIFC court rules. And that overriding objective is to enable the court to deal with cases justly. The relevant rule in part 1 of the court rules then explains what dealing with the case justly means, and in broad terms, there are some further details in the rule itself. That includes, firstly, ensuring that the system of justice is accessible and fair. Secondly, ensuring that the parties are on an equal footing. Thirdly, ensuring that the case is dealt with expeditiously and effectively. And fourthly, dealing with the case in ways which are proportionate. So those are the main aspects of dealing with cases justly. They're expressed in terms similar to the overarching objective in the English civil procedure rules, which I'll mention again shortly. I say it's the golden thread because Rule 1.7 requires, firstly, that the overriding objective must be given effect to when the court is exercising any power or discretion under the rules. And secondly, it's something which has force when the court is seeking to interpret any rule or practice direction. So it has a significant force in both those respects. The overriding objective in the context of interim measures is well described by Lord Hoffman in the National Commercial Bank case, where he said the purpose of an interim remedy is to improve the chances of the court being able to do justice after a determination of the merits of the trial. I would add this: it's important to remember that in this context, we are looking at justice from the perspective of all parties, and what an applicant for an interim remedy may say would do justice to them may be something which the respondent says would do injustice to them. And so it's important to remember that justice is something which needs to be looked at in the round, having regard to the interests of all the parties and the interests of justice objectively as well. So from an applicant's perspective, it's important that the final determination of the proceedings is meaningful and isn't rendered academic because the respondent has dissipated their funds or destroyed evidence, for example. But from a defendant or respondent's perspective, it's important from their point of view that they're not the subject of, for example, multiple oppressive applications for interim relief that seek to or may have the effect of compelling the defendant to concede a claim which is actually without merit. So it's important to remember that the principles of justice need to be looked at from the perspective of all parties. I mentioned a moment ago a judgment of Lord Hoffman in a case from the UK Privy Council. Why is that relevant? Well, it's relevant because both the AIFC constitutional statute and the court regulations make clear that judgments of courts in other common law jurisdictions beyond the AIFC are relevant and may guide decisions of the court. It's not inconceivable that the court may, in some circumstances, decide to take into account, but take a different stance in relation to, for example, AIFC court rules, which are slightly differently worded from a rule that's the subject of overseas common law judgment, but nonetheless, they are in principle of a significant persuasive force. And that means that it's worth considering in a case which you may be involved in, which concerns a dispute about an interim remedy, worth considering the rules and the case law about those rules in other common law jurisdictions. Broadly speaking, they are quite similar to Part 15. I mentioned the three that seem to me to be the most similar, certainly the three that I'm most familiar with, that I think are the most familiar. The English Civil Procedure Rules, Part 25. The CPR were the brainchild of Lord Wolfe, who of course was the first Chief Justice of the AIFC Court. And Part 25 makes similar provision for interim remedies. Part 29 of the Hong Kong rules of the High Court, and those rules were themselves modelled with some refinements on the English CPR, and Part 25 of the Dubai IFC Court rules. In England and Hong Kong, there is a book which some of you may be familiar with, the White Book, as it's known colloquially, which sets out the procedure rules and contains quite extensive commentary on the case law decided under those rules. And it may well be useful for anybody engaged in a debate about interim remedies under Part 15 of the AIFC rules to have regard to the White Book and what it says about the case law in England. There is also a White Book applicable to Hong Kong. I believe there is one in Northern Ireland too. You can get them online. They're available on Westlaw, for example, for those who have access to Westlaw. I'm turning then now to interim injunctions as the first aspect of interim remedies that I'll be looking at in some more detail. And the lead case in relation to interim injunctions is a judgment, a decision of the House of Lords, the predecessor to what is now the UK Supreme Court, in a case called American Cyanamid. And the key principles are, firstly, is there a serious issue to be tried? If the case brought by a claimant is, for example, hopeless, without any strong prospect of success, then that would tell against granting an interim injunction. Would damages be an adequate remedy if, for example, the claimant is seeking to preserve the status quo in any particular way, but in fact, if there wasn't an order, that anything that happened between that moment and the final determination of the trial could be made good to the claimant through an award of damages, then that may tell against a interim injunction. Is the claimant prepared to provide what's known as a cross undertaking in damages to the respondent? What a cross undertaking is a respondent may say, well, look, if we are required to do or not to do something between an early stage in this litigation and the final determination to claim, if the claim is subsequently found to be without merit, we will have been prejudiced because we will have been the subject of a court order in what is ultimately an unmeritorious claim that may have perhaps restrained our ability to undertake a transaction, and that may have caused us prejudice. And so the claimant may or would ordinarily be expected to provide a cross undertaking in damages to the party that is to be the subject of the interim injunction, effectively indemnifying or to a certain specified extent indemnifying the respondent from prejudice. Particularly in circumstances where there is doubt as to whether damages will be either an adequate remedy to the claimant if an injunction wasn't granted, or an inadequate remedy for the respondent if a cross undertaking is granted, and whether that be adequate to protect the respondent from prejudice, then the overall tiebreaker will be what's known as the balance of convenience, which is really another way of expressing what is the just thing to do in all the circumstances having regard to the potential prejudice to the claimant if an injunction isn't granted, and the potential prejudice to the defendant if an injunction is granted. Where's the balance of justice to be struck in the particular case? I would say here that I would strike a note of caution in respect of seeking to read across judgments as to where the balance of convenience is struck on the fact of any one particular case to a particular dispute you may be involved in, because for the most part, the striking of the balance of the convenience will be specific to the facts, or at least highly influenced by the facts of the particular case. I now quote a passage by Lord Diplock, who gave the lead judgment, or the only judgment in the American cyanamide case. What he said is, where other factors appear to be evenly balanced, it's a counsel of prudence to take such measures as are calculated to preserve the status quo, in other words, to maintain the current position. If the defendant is required temporarily not to do something he hasn't done before, the only effect of the injunction is to postpone the date at which he's able to embark upon a course of action which he hasn't previously found it necessary to undertake. Whereas to interrupt him in the conduct of an established enterprise would cause much greater inconvenience to him. In other words, a court is likely ordinarily to be more ready to grant an interim injunction where it preserves the current position, preserves the status quo. Where the interim injunction would bring about a change from the status quo, the court is likely to need more to be persuaded that that would be the just thing to do. And a matter of practical tip, which I put in bold at the end of this slide, the evidence in support of, or in opposition to, depending on which party you're representing, an interim injunction must address these considerations. It's standard practice, for example, for a witness statement or affidavit to be structured by reference to those four principles I've set out, and to draw attention to whether the interim injunction sought is something which would maintain the status quo or change it. And similarly, a skeleton argument prepared by the advocate or advocates in the case would ordinarily also address directly those principles. The case law from England has also been clear that the interim injunction sought, and I should add perhaps in brackets here that the party seeking the interim injunction will be expected to prepare a draft order and submit that with the application. It must be worded in terms that are sufficiently certain. In other words, the person proposed to be affected by the injunction needs to be able to understand precisely what he, she, or it is to be required to do or prevented from doing. And if it's not possible for the applicant to define the order with a sufficient degree of precision, then the court's unlikely to be persuaded to grant the order, at least in those terms, simply because of principles of legal certainty. So anybody acting for an applicant in proceedings where an interim injunction is sought, I'd advise that before they make the application, they think about the draft order from the perspective of someone having to comply with it and ask themselves, is this worded in terms which, if I was the subject of this order, I would know what the dividing line is between something which would comply with the order and something which would not. And if the answer is no, I wouldn't understand where the dividing line is, then you would need to amend that draft order before submitting it. So that's the responsibility of the lawyers. Also, it's worth noting that in some cases, a defendant may consider it preferable to offer an undertaking to the court. That's a legal speak in the common law for a legally enforceable promise to the court in place of an interim injunction. That may come about because there's been an interim injunction imposed on a defendant without notice, and the defendant then says, well, lift the injunction and I'll make an undertaking instead. Or it may be where the defendant has notice of an application but offers up an undertaking instead, and that may give a defendant a greater degree of control over the precise description of what the defendant can and can't do. That may be seen as an advantage by the defendant and their lawyers in particular cases. There is case law, again, from England and Wales, to the effect that where a defendant does do that and give an undertaking, but wishes to be preserve its rights to be released from the undertaking in the future, it's usually necessary for the undertakings to express within them, the wording actually to express the opportunity to the defendant to seek to be released from the undertaking. So once again, the precise wording is the responsibility of the party advocating in this case, the undertaking. It is sometimes possible where there's good cause to release a defendant from an undertaking that doesn't have that reservation. It's possible, but it's good practice and the safest option to include provision for release. I now turn to the subject of freezing orders. They are the subject, as I mentioned in one of my earlier slides, of two specific provisions within the court rules of the AIFC Court, 15.1 paragraph 6 and paragraph 7. A freezing order itself is an order restraining a party from removing assets from Kazakhstan or from dealing with assets wherever they may be located, a broader category than simply removing assets from Kazakhstan. And then there's a related order available, which is to require a party to provide information about assets which either are or which may be the subject of a freezing order. I should add at this stage that that related order available, an order requiring a party to provide information in relation to assets which are not yet the subject of a freezing order, that order there's authority from England and Wales. There's an order of that nature would normally only be granted by the court if there were credible grounds believing that there are assets which might properly be the subject of a subsequent freezing order. This order would not be granted to a party undergoing what lawyers in London and England call a fishing expedition. It's not there to enable a claimant speculatively to try and find out for no good reason what assets a defendant may have. And that's an illustration of the point I made earlier, that the principle of dealing with cases justly in this context needs to be applied not simply from the claimant's perspective, but also having regards to the interests of the defendant and any other parties. A freezing order is a form of injunction, and therefore the principles relating to injunctions apply with some modifications. In England, we actually call them freezing injunctions. They're called freezing orders in the AIFC court rules, but the provisions of the rules make clear that the rules treat them as a form of injunction. And so, subject to the refinements that I outline and other principles set out in the rules, in general terms, the principles I've talked about relating to injunctions also apply to freezing orders. What's the purpose of a freezing order? Well, in broad terms, it's to prevent the dissipation of assets which would otherwise be available to meet a judgment. So if a claimant is suing a defendant, for example, for a sum of money, and there is a sufficient prospect that the defendant may, before the judgment is made, dissipate their assets so that they wouldn't, even if they lost the case and was required to pay the defendant some money, they wouldn't have the money, then the freezing order protects the position of the claimant by stopping the defendant from doing that. The test for freezing, or the principles applicable to whether a freezing injunction should be granted, there's an awful lot of text in the White Book, an awful lot of case law applicable to this, but the main features I summarise in these 3 bullets at the end of this slide and on the subsequent slides. Firstly, there needs to be a good arguable case. There is authority in England and Wales, as it happens from a case with a Kazakhstan angle, where the court held that there isn't a need to show a greater than 50% chance of success. The trial judge in that case had proceeded on the basis that the claimant seeking the freezing order needed to show that they had much the better of the arguments likely to come forward at the trial. The Court of Appeal said that was raising the hurdle too high. There need to be grounds for believing that there are assets on which the judgment would bite. In other words, that the freezing order is likely to be something which is meaningful and necessary, as opposed to it being purely speculative. And there needs to be a real risk of dissipation of assets. It's not sufficient that the defendant has the assets. There needs to be a real risk that they will be dissipated, and it's important for a claimant to address that requirement and explain why there is a real risk in the evidence put forward in support of the application for a freezing order. This next slide sets out some of the typical factors that are influential in deciding whether there is a real risk that the respondent will dissipate their assets. I must stress these are not criteria, these are not rules, these are simply some common features of the case law, particularly for England and Wales, relating to this matter. So firstly, the ease or difficulty with which the respondent's assets could be disposed of or dissipated. If the assets are tied up and it would be hard for the respondent to disperse them before the trial, that's likely to tell in against a freezing order. If they could readily and quickly be dissipated, that is likely to tell in favour of a freezing order. The nature and financial standing of the respondent's business, if they are a business or engaged in business, it is likely to be harder for an applicant to get a freezing order if the respondent against whom the order is sought is a long-established business with a reasonable market reputation. Whereas if the respondent is a more recent emergent in the market and or has a track record of having done something such as dispersing assets, or a track record of malpractice, that is likely to tell to be influential. The domicile of the respondent, there is a pattern in the English case law that a respondent that is not domiciled in the English jurisdiction, the UK territory, is likely to be in a position where the courts would be more receptive to a freezing order than a UK domicile, and that may be a factor which applies in Kazakhstan, namely a party which is domiciled in Kazakhstan or does business in the AIFC is a party that is less likely to be the subject of a freezing order than one that is externally domiciled. If the respondent has expressed any threat or intention about future dealings with their assets, that's likely to be very persuasive, obviously, because that would be, in principle, quite highly probative evidence that there is a real risk of dissipation. And similarly, if in the proceedings up until the point where a freezing order is sought, the respondent has behaved in a way that would indicate there is a real risk of them dissipating assets. For example, they've been evasive or they haven't engaged at all with the claim, that is likely to be highly persuasive. As of course is evidence of dishonesty, provided that evidence justifies the inference that the respondent will dissipate assets. Evidence of dishonesty without that dishonesty being probative of a likelihood that the respondent will dissipate assets is not enough. The dishonesty has to be relevant to the question of, is there a real risk that assets will be dissipated? Ordinarily, a freezing order will require a defendant to provide information about their assets so as to make that order meaningful and compliance with it capable of being monitored. I repeat what I said at the outset, like any other order, a freezing order is something which, if it's breached, would mean that the party in breach of it would be in contempt of court. Like all other interim remedies, a freezing order is temporary in nature. It's an interim remedy, not a permanent remedy. What that means is that where a claimant has obtained a freezing order against a defendant, it must press on quickly with the claim. There is authority from the Privy Council to the effect that where a claimant has obtained a freezing order and then does not pursue the claim with appropriate speed, that can be an abusive process. And an abusive process is capable of being a ground for a claim being struck out. And it's also, in any event, a basis on which a freezing order may be discharged. However, although a freezing order is an interim remedy, it may, in some cases, be a remedy that can be granted after judgment, but before the process of the execution of the judgment, because it is conceivable that in a particular case, depending on the facts, a party is the subject of a judgment saying they have to pay the claimants a sum of money, for example, but that there will be a time delay between that judgment and the execution of the judgment, and the beneficiary of the judgment, the creditor, ordinarily the claimant, would want to protect their position and make sure the money isn't dissipated. The assets that would fund that judgment debt aren't dissipated. And it's possible, therefore, to get a freezing injunction subject to the relevant principles being satisfied between the judgment and the execution. I told you at the beginning I'd give an example of an interim declaration under Rule 15.1, paragraph 2. And one example is where, which is set out in the case law, where if a party has been found to have been in breach of a freezing order, they've undertaken a transaction that they were required not to have done, and have been found to be in contempt of court, they may feel it appropriate, or they may be required to undertake a further transaction to undo the contemptuous transaction and effectively right their previous wrong. And in the case I cite there, the ABC case, the party in question wanted to make sure that that second transaction that they wanted to right their previous wrong by wouldn't be a further breach of the freezing order to which they were subject. And that was something which they sought an interim declaration. It was an interim declaration because it related to an interim remedy rather than being a permanent declaration at the end of the proceedings. So that's one example of an interim declaration. I now leave the subject of interim payments and I leave the subject of freezing orders and turn to the subject of interim payments. Interim payments, in very general terms, are where a party who is highly likely to have to pay a sum of money other than costs to a claimant is required to pay a reasonable proportion of that money in advance to protect the judgment creditor's position. The circumstances in which a interim payment may be required to be made are set out in Rule 15.18, and they are set out in the first 4 bullets under this slide, where the defendant has admitted that they're liable to pay damages or some other sum of money to the claimant, where the claimant has obtained a judgment saying that the defendant is liable, but where the amount of damages has yet to be determined, and that would be the matter of a separate judgment. Thirdly, where the court is satisfied that the claimant would obtain judgment for a substantial sum of money. In other words, where the real uncertainty at trial is not whether the defendant would have to pay the money, but how much. And then there are some special criteria applicable in the rules where there are multiple defendants. The interim payment, it can't be more than what the rules describe as a reasonable proportion of the likely amount of the final judgment. What is a reasonable proportion will depend upon the facts of the case. An illustration, and it really only is that, is the case I mentioned here, the Pfizer case, where in that particular case, the reasonable proportion was 75% of the estimated profits that the defendant would have made by infringing the claimant's trademark. So the claim was about a breach of a trademark. The likely profits were projected, and the reasonable proportion made by way of an interim payment was 75%. I stress that's only an illustration, and it shouldn't be thought that 75% is a rule or anything approaching a rule. Where an interim payment has been made, it may subsequently be varied. It may subsequently be required to be repaid if, for example, circumstances change. And of course, if the defendant ultimately has to pay, is required to pay at the end of the proceedings less than the sum that they've paid by way of an interim payment, they get the difference back, and they get it back with interest. It's also a rule that the fact that an interim payment has been made must not be disclosed to the trial judge. As is probably obvious, the reason for that is to avoid any prejudice to the party required to pay the interim payment by the judge's view of the merits of the case being clouded by the knowledge that an interim payment has been made. In practice, that will mean, of course, that the trial judge is a different judge to the judge who determines any dispute about whether interim payment is made. I now turn to security for costs. In some senses, this is the equivalent in the context of costs of an interim payment, and which obviously interim payments relates to matters other than costs. And the purpose of security to costs is to protect against protect a defendant against the risk of them not being able to enforce a costs order against the claimant. So they're the subject of proceedings by the claimant, and if there's a real risk, the claimant may not ultimately be able to pay the costs of the case if the claimant fails in the claim. The general rule being that the unsuccessful party in litigation pays the successful party's reasonable proportionate costs, that the defendant may feel that they need to be insulated against the risk that they will be successfully see off the claim but not to be able to recover their costs of doing so, and that of course would not be ordinarily not be just. Rule 15.29 is the source of the court's power to make an order for security of costs. The parties that can apply for security for costs are the defendant to any claim, and any claim means both the main claim, or there is a concept of an additional claim whereby there may be subsidiary claims brought within the main claim, what we in England call a Part 20 claim, Part 13 in the AIFC Court rules. However, it's not possible to apply for security of costs against the AFSA or the Register of Companies in proceedings which they've initiated. Broadly speaking, the time to apply for security costs is as soon as possible, no later than the first case management conference. There are two consequences of delay. Firstly, in practical terms, the protection that a defendant will get in relation to costs will be less, because security for costs is limited to future costs. But secondly, also the court may be less convinced that an order for security for costs is appropriate if the defendant has unduly delayed in applying, certainly unless the defendants can explain that there's good reasons for that. So it may undermine an application. Multiple applications for security for costs sometimes happen, and again, I'm pleased to provide some case law with a Kazakhstan angle from the English Court of Appeal, where it was held that where an earlier first application for security for costs was unsuccessful, or where it resulted in an order for security for costs in an amount now said to be insufficient, the applicant may reapply for security for costs, provided that they can show some significant and relevant change of circumstances. So there's no absolute prohibition on multiple applications for security for costs, provided that there's good reason for the second or subsequent application. And the overarching principle for whether an order should be granted is the good reason to believe the claimant won't pay the defendant's costs if the defendant is successful at trial. There are various preconditions, at least one of which must be met. They're set out in Rule 15.30. They include to stress that it's only one or more conditions. They don't all have to be satisfied. The claimant is resident outside Kazakhstan. The claimant is a company with no or limited assets, and so will be unable to pay the costs, or the claimant took steps in relation to his or its assets to make it difficult to enforce the cost order. An example of a case I've been involved in as an advocate in England and Wales where security for costs was granted was where the claimant, there were a group of individuals affected by a authority's decision, and they set up a special purpose vehicle company, a shell company, and brought the claim through that shell company, a case called Residents Against Waste Site in Lancashire County Council, and the defendant for whom I acted sought and obtained security for costs on the basis that the setting up of that shell company as a litigation vehicle gave good reason to believe that the claimant was managing its activities in such a way as to make it difficult for the defendant to get costs against the claimant, and the order for security costs was granted. Sometimes, I should add, sometimes where security for costs is sought, there will then be a process of negotiation between the parties, and the court won't ultimately have to determine the application of security of costs, because through correspondence or discussions, the parties will agree an appropriate amount of security for costs. A few comments on procedure before I wrap up and take some questions. Broadly speaking, we're subject to any specific exceptions in the rule. An applicant may seek an interim remedy at any time. There is a proviso to that, which is that Rule 15.4 provides that normally a defendant can't apply for an interim remedy before he's filed his acknowledgement of service in defence. The principle there being that until one can see what the defendant's case will be, the appropriateness of an interim remedy that they seek may be hard to judge. There's no absolute bar on making multiple applications for the same interim remedy, and I've given some examples I've gone through of where that may be appropriate. But where a second application is made based upon material but which wasn't, but which could have been used on the unsuccessful first application, the court is unlikely to be impressed. I deliberately use the words unlikely to be impressed because, as with everything in this context, it all turns on the facts of the case, and there may be good reasons for understanding why the material wasn't used the first application. But broadly speaking, it's not a good start for a second application if it's based upon material which either was or could have been used on the first application. There are particular rules applicable in relation to interim remedies before a claim is brought. I draw your attention to them in that second bold bullet. Turning to the third bold bullet, the general procedure for seeking an interim remedy after a claim is brought is set out in Part 6 in relation to applications, Part 6 of the AIFC Court rules. It's necessary to file an application notice, with a copy of the order sought, and I've explained that drafting the order is something which requires particular skill and care on behalf of on the part of the applicant's lawyers, and evidence, ordinarily through a witness statement or in relation to injunctions and freezing orders and affidavit, verified by a statement of truth. And that, as I explained, that evidence needs to address directly the relevant principles relating to the particular form of interim remedy sought. Some particular considerations applicable to interim injunctions, including freezing orders. Often they take place without notice, because if they were to take place on notice to the respondent, that may mean that the purpose of, for example, the freezing order is defeated. If the freezing order is there to stop the defendant dissipating assets, because as a realist they'll do so, if the defendant knows it's coming, they may dissipate the assets before the freezing order is made. So what often happens is that it's done without notice, or what used to be called an ex parte basis, in which case the applicant must provide an undertaking, an enforceable promise to the court to serve the application notice, the evidence of support, and any order made on the respondent thereafter. The court may expect the applicant to explain why there's a real urgency necessitating a without notice application, and so that should be covered off in the evidence in support of the application. There would then be what's called a return date, a second hearing, and that second hearing would be where all parties affected, whether it's two or multiple parties affected by the order, are present, and those that are the subject of the order can try to persuade the court either that the order should be lifted or that it should be varied. There's a duty on the party or parties seeking the interim remedy to be full and frank in their disclosure of relevant facts, including the facts that may be relied upon by the respondent. That's particularly relevant in the context of without notice applications, where the only party the court is hearing from is the applicant, and the applicant's lawyers are under an important duty to the court to make sure the court has the fullest picture. As I explained already, there's an undertaking in damages offered by a party that is seeking interim injunction. And I'm going to move forward, given the time, to the next final slide. Just a few points about advocacy, and with apologies to those who on this webinar who attended the advocacy masterclass I gave last summer, because I borrowed this slide from that, but some key points in relation to advocacy at an interim remedy hearing: make use of your time effectively. The hearing is likely to be short in most cases, and so you need to make sure that you are concise. Know the facts, the procedural history, know where the documents are so that you don't lose the attention of the court. Make sure you're fully aware of the judge's powers and the applicable law. I reiterate once again that the AIFC court rules are your friend. They're really important. It's worth having both a soft copy and, if you can get hold of the hard copy too, and make sure you know your way round the rules, not just part 15, but part 6 and applications and any other parts of the rules that may potentially be relevant. Structure is important. Submissions. What you want to tell the court: what do you want, why do you want it, and how can the court give it to you? Where in the rules is the court's power? Ordinarily make the submission first and then go to the evidence that justifies the submission. For example, if you're going through the American cyanamide criteria, make your submission as to why damages is not an adequate remedy, and then go to the evidence which shows the court why damages would not be an adequate remedy. Sometimes where there may be multiple applications and it may be necessary to establish the order of play beforehand, ordinarily do that with the other parties, and there can be some tactical advantages. I won't mention names, but I did an interim hearing not that long ago against another party, and each party had an application for an interim remedy, and it seemed to me to be sensible to let the other side go first for tactical reasons, partly because it gave me the chance to respond and see the case against me, but partly also because the other advocate had a reputation for being rather boring, and I thought if they bored the court first, that would give me an advantage. So tactical considerations may come into play too. I would also add in the current time that interim hearings are particularly strong candidates for hearing through remote mechanisms rather than in-person hearings. And I expect that following the current coronavirus crisis, we will see a higher proportion of interim hearings in all common law courts taking place remotely than was the case prior to the current coronavirus crisis. And finally, I add on the subject of advocacy that once again this year, as was the case last year, the AIFC Court and International Arbitration will be providing a free of charge common law advocacy training. Chris will advertise the details via the AIFC Court and IAC websites. And once again, that will include a Russian-speaking barrister from London, which hopefully will be an advantage.